can already feel the heat.
Thank you. The state then called Julius Malema and Gerardo Snyman, case number Divisional Court 446 of 2020. Mr. Chairman, just put the proceedings on record. The date is the 31st, or the 30th, of January 2023. The parties are the same as before. Presiding officer, Mr. Steve Olivier. Public prosecutor, the James Caesar. For the defense, Advocate L. Hobbs, appearing for accused number 1. Advocate Matthews appearing on behalf of accused number 2. We don't need an interpreter. The proceedings will be conducted in English. The clerk is Ms. Magdunta.
Before we start then, for the record, Advocate Otis, the defense with regards to accused number 1 are ready to proceed. Thank you. Advocate Matthews. Thank you. Apologies in the delay in starting, but also due to load shedding we had to wait for the service to kick in, and I've also just recently been supplied with various media applications. So I will acknowledge and place on record the approval of the following. If I leave anyone out, as I did on the last appearance, please inform me. The first one, or the application received this morning, is the name of the applicant Sinawe Tambo on behalf of the EFF. Since the matter is of public interest and involves the party leader, Mr. Malema. Yes, thank you. That unfortunately that industrial aircon affects our recording. Sorry for that. The second application is one received by AfriForum, and you are then also approved and acknowledged. Application from ENCA, approved and acknowledged. Further application by Galen Nair on behalf of Newsroom Africa, received and acknowledged, as well as Yuri Bluffnote on behalf of SABC News, received and acknowledged. The only amendment I would like to make to the applications received is the one on behalf of AfriForum, where it is requested that still photos be taken whilst the court is in session. That is not allowed. Before proceedings, after proceedings, or during adjournments, but not during court sessions. Everybody happy with that proviso, Mr. Caesar?
Yes, the court please here. Motion got no objections.
Advocate Otis? Thank you. There's a further request then. Firstly, let me just read out. For record purposes, all the media houses who are acknowledged, you are fully aware of the rules pertaining to the media, so I'm not going to repeat that. Safe to say the following requests have been agreed to by the state as well as the defense. Firstly, the microphones for cell phone recordings of any kind close to the defense where they liaise with each other is private and to be removed from the bench where they are seated. That includes the bench or the dock of accused 1 and 2. That is correctly stated as per our agreement. Yes, and then with regards to the witness and the cameras on that side, unfortunately, if you want, I will ask the camera person regarding the state witnesses, please not to sit in my view because it blocks my view from seeing the witness, and observation and seeing plays a vital part in proceedings. What else was there? Further, the state has also alleged that there may be applications where certain witnesses who will testify, they will request that it not be filmed, but the audio evidence of that witness will be allowed. But he will warn if the case is, if it does occur, he will inform us timely. Okay. Is there anything else that I left out, Advocate Caesar?
Nothing. No.
Advocate Matthews?
Nothing.
Oh, sorry, Advocate Odes
Nothing.
and Matthews. No. Thank you. So, since we are all ready, we may proceed.
Thank you, Your Worship. State then called in Lieutenant Colonel Mandisi Ngwadleka. Mandisi Ngwadleka. Worship, just for record purposes, I have finalized my question in regard to this particular witness at this stage.
Just a second, I'll be with you now. Excuse me, I'm going to turn my back and head on the court. I see there's a fan here which I'm going to plug in. Sorry.
Just for record purposes, this witness evidence was televised. The last occasion, he had no objection to the video being taken of him.
Do we have an interpreter? Oh, thank you, I didn't see. The witness, Mr. Mandisa Nkandleka, you are reminded that you are still under oath in this matter. The state has finalized evidence. Advocate Odes, I'll just check you have you finished and started and finished.
Yes.
And cross-examination, Advocate Matthews?
It was also complete. And the state had no re-examination.
Yeah.
That's all been complete.
This is what I've got. Evidence in chief done, exhibit handed to court, cross-examined by Advocate Odes, and then make mention of you according to the record. I'll just check my notes for absolute certainty. Just a minute. Yes, indeed, that is the case. I wasn't sure if this is the witness where the court indicated it may still recall.
The last witness said, Your Worship, was you said there was re-examination from my learned colleague. His last question was SPA 249 a toy or real? And
Yeah.
the witness confirmed it's a firearm in terms of the Firearm Control Act.
Yes.
And the court said we're holding over questions to avoid a 186 recall.
Yes.
That was the last.
Yes, I just want to that is still the position then. So at this stage, then the witness, you are excused. For now, we have finalized your evidence. You may stand up. Thank you. Yes, please. Thank you. Advocate Cesar?
Thank you, Your Worship. At this stage, if I may just request a short adjournment, as I thought the court was going to have questions for this particular witness.
No. If you recall, I indicated if I reserve that, and then if it should, I will notify all of you the day in advance if it suits the witness, so that I don't delay your sequence of witnesses. That
Yes.
was my understanding,
Yes,
if I recall correctly.
Yes, thank you, Your Worship. Your Worship, my witnesses have just flown in. They're on their way. If I may just ask for a short adjournment until 11:15, then we can continue.
Okay. We will also arrange amongst ourselves to try to work in the load shedding loss of time.
That's correct. Thank you, Your Worship.
Thank you. We can go on record, Excellency.
Thank you, Your Worship. We're back on record. Your Worship, firstly, I want to apologize for not starting at 11:15. We're just trying to set up the television and everything else. My apologies for that.
Thank you. Let's proceed.
Thank you, Your Worship. Your Worship, we're about to go into another phase of the evidence regarding video evidence. My witnesses are present. I just want to ascertain at this stage if there is any objections regarding the evidence that is going to be led.
Worship, my learned friend knows, and I've made it very clear to him, that there is an objection. The authenticity and originality of the video evidence is in dispute. It has always been in dispute, and he's well aware of it. Your Worship, I can elaborate on that to perhaps assist and guide my learned friend in this regard.
Sorry, Advocate Matthews, if you'll just give me a second to get myself in order and note the state's application, and then I can be with you to. And if there's any or he can reply, I don't know which way is he going to apply, then objection, which way do you want to do?
I'm raising an objection, so that you can answer and I'll reply. Worship, a video is a photograph and film is considered as real evidence. Such items such as photographs are regarded as documents for the purposes of Part 6 of the Civil Proceedings Evidence Act 25 of 1965. And more specifically, Worship, Section 34.4. There's also the established decision of Rangoban, Worship, State v. Rangoban, that goes back to 1986. It's reported as 1986, Volume 4, the South African Law Reports, page 117, decision of the Natal Provincial Division as it then was. Your Worship, Marlon and friends wants to adduce evidence by way of video in circumstances where there's no cameraman that comes to court and says, I personally made this video. There are various versions, Your Worship, that went on the social media concerning this incident. They differ. But over and above that, Your Worship, there isn't a person that can be brought to court to say, I am the cameraman that filmed this video. To put it practically, Your Worship, here we are in the court of law. There are cameras running. Your Worship authorized them. Should there be any dispute, each and every one of these cameramen that are manning the cameras can come and say, I manned the camera, this is what I filmed on that day. In these circumstances, Your Worship, the state is unable to do so. And they have an obligation, Your Worship, in law to prove that a document, or in this instance the video footage, is authentic before it may be received as evidence before Your Worship. The same would apply to a particular document or a photograph, Your Worship. So my learned friend knows that he doesn't have any person who comes forward before the court to say, I produced this video. Over and above that, Your Worship, and we have had insight into the docket, the actual video machine has been stolen or lost subsequent to the event. So our respectful submission, Your Worship, is that the state will not be able to prove the authenticity and originality of the video footage, which results in it not being admissible, Your Worship. It's not a question of the weight to be attributed to it. They need to pass two hurdles first, and that is to say, here is the person who filmed the video on that date. He can attest to the reliability and the fact that there was no interference. We state up front, Your Worship, that the state know that they're incapable of doing it. We therefore contest the admissibility of the video footage, Your Worship. Listen, may I approach the accused? He wants to tell me something. I don't want to be rude and turn my back.
Certainly, thank you.
Thank you. Thank you, Worship.
Thank you, Advocate. Advocate Matthews.
Thank you, Valerie. Valerie, in this particular matter, emanating from the docket, there are two possibilities of video evidence. The one appears on, was posted on social media, and the other one is, I think, the video which my colleague now wishes to lead evidence on. The one on social media, we have absolutely no evidence about this, who took it, where it was taken, when it was taken, etc. The one he now wants to prove, we have no evidence as to the actual operator of any instrument which recorded this video. It boils down in proof of this matter as to whether one can find a distinction between it being real evidence or documentary evidence. This is an old argument which has been going on for a lengthy period of time, and which the Supreme Court of Appeal has seen fit not to resolve. So we could start with arguing about Ramgarbon is the right case, and the state could argue that Baleka is the right case to deal with this matter. The Eastern Cape, we have a decision of state versus Ndiki. I'll spell it for you. The NDIKI. It's 2007, volume 2, all South African law reports at 185C. K, paragraph 20. That decision has followed State versus Ramgoven. Now, what Ramgoven found was that before such evidence can be admissible before the court, there are a number of prerequisites. Firstly, it must be proved that this is an original document. So in order to do so, we have to have the evidence of the person who took it. As my learned colleague has now raised, we have no evidence in the document of anybody who took this particular video. Then we need to authenticate, the state needs to authenticate this video, in other words, call expert evidence to say that it has not been tampered or changed in any manner whatsoever. We also then need a witness to come and testify that in fact this video shows the actual happenings on the day in question. So somebody who was present and can testify to the fact that what we are looking at is what the charge sheet alleged. My lady, in deciding whether this is real or documentary evidence, there are a number of sources which state that the court should look at what the purpose of this evidence is. I'll read out. It says it appears from a number of sources, and the sources quoted are Smith and Zeppert of evidence, de Villiers, State versus Ramgoven, and this Nditi case. And when a court is tasked with determining whether evidence should be dealt with as documentary or real evidence, the purpose for which the evidence is presented should be taken into account. If the presenter's purpose is for the court to read or listen to and interpret the contents of a piece of evidence, such evidence should be considered documentary evidence. If the fact in issue is whether the document exists, the condition thereof, or some other issue relating to the document's appearance, then it is real evidence. I can see now the purpose why the court would want to show this evidence to you is wants you to read, to listen to and interpret the contents of this evidence. And therefore it is documentary evidence. This documentary evidence, then the rules apply, as my learned colleague has set out, that it is required for the state to prove its originality as well as its authenticity, as well as a witness to establish that it is what it depicts to be. In other words, somebody who was present when it was taken. We also object to this particular evidence being admitted before the court until these steps have been taken. My lady, the only way to resolve this issue is to deal with this matter in a trial within a trial. And for my lady to make a ruling at the end of the day as to whether this evidence is admissible or not. Because in essence we are dealing with a question of admissibility.
Thank you. Thank you. Just before I listen to your argument, Advocate Caesar, I just want to pose one question to the defense. From the top of my mind, I was not even aware we reached the stage of proceedings, so I'm also caught by surprise, but then you can answer at the same time. From the top of my head, I'm referring to the State versus Fury, 1994, 2 SACR Appellate Division, where documentary evidence was ruled admissible, and that the key element to be answered was it relevant, and I've not heard the defense reply regarding relevance.
My lady, that particular decision pertained to a document, a written document.
It pertained to a speed camera and the calibration or what from regarding the speeding camera, and whether it should be authenticated, and I'm just saying in the end it was ruled to be admissible, and relevance played a part. So
Yes.
I don't know if you wish
Yes.
to address me on that aspect.
Yes, my lady. I think when you're dealing with a speed camera, the correct working of the camera in question is usually in dispute.
Yes, the
In other words, the
calibration.
state has to prove that it was operating correctly
Yes,
and that when it took the speed reading. Relevance forms are, of course, a very important part because
Yes.
we wouldn't leave that evidence is not relevant to the charge.
exactly.
As we have in this particular matter, whether this video is relevant to this charge or not. But that is a decision you would only be able to find to deal with once you proceed in the trial within a trial. Whether it's relevant to the charge.
And the common law principles pertaining to issues of this nature, where the court makes a distinction as to what is required regarding statutory, case law and the common law.
The problem is this. Our common law is based at the time when this type of instruments were nowhere to be seen.
Exactly.
We are now entering a phase where the law has fallen far behind
Technology.
technology. An attempt has been made to, I must say, bring it into line with numerous acts. The Civil Proceedings Evidence Act, the Electronic Communications and Transitions Act. There's a new one, which is, I can't even remember, which deals with data evidence and how the proving of all of that must take place. Nevertheless, the further we get into this type of evidence in the law, the more possibility that there exists that it can be fiddled with. I'll give an example, which is probably not a good one, but videos posted on the social network claiming to be evidence of storm damage taken in Durban on a certain date was shown that that video evidence was in fact from a previous storm that happened 3 years ago. So the danger to the courts of accepting this type of evidence can never be overemphasized. And with a video such as this that the state wants to show, it is of crucial importance that before my lady accepts this evidence, it has to be shown that it is authentic, it is original, it has not been tampered with, and it is authentic evidence. Otherwise, my lady, it is so easy to, in modern society, to be able to make a video which purports to show X, Y, Z, but in fact, that is not in fact what happened. I could even go further and tell my lady that a few days ago I was watching a program on Al Jazeera about a bomb blast. And these people showed that the bomb was detonated. 20 minutes later, everybody arrived and lay in position, allegedly having been blown up by this bomb blast. And then that incident was then distributed on the net as if it had happened exactly the same time. We cannot be enough careful. I agree with my learned colleague that before the state has proved originality and that this video is authentic and has not been tampered with, it should not be shown to them.
Okay, just for the record, I may add, I don't know what video the state is wanting to show. I'll hear from them. Regarding the viral social video, I've not seen it at all. Maybe I'm the only person in South Africa, but I've never seen it. For the record. Advocate Odes?
Your Worship, may I answer your Worship's question?
Certainly.
Worship, this is dealt with expressly in the book by the learned authors Hoffman and Zeffert. Worship, and it's the latest edition at page 709, with a specific reference to the case that your worship refers to.
Fury.
That being State versus Fury, which is reported as 1994, volume 2 of the South African Criminal Law Reports, page 829. As your ladyship said, the decision of the appellate division. There the learned authors make the distinction very clear, your worship, and they state as follows, and I quote from them, your worship. In State versus Fury, it is held that a photograph of a moving motor vehicle by a so-called speed camera was admissible without a witness testifying that it was the correct image, because the reliability of the camera is not an issue and there was no dispute that it had been properly set up and operated. So that's the distinction here, my lady. If one goes back historically to the decision of Milne JP as he was at the time in the State versus Ramgoban, he established the following criteria based upon the American practice, your worship. And it's on the same page in Hoffman and Zeffert. It says, and these are the requirements for admissibility of sound recordings, your worship. It says 1, showing that the recording device was capable of taking testimony. 2, showing that the operator of the device was competent. 3, establishment of the authenticity and correctness of the recording. 4, showing that changes, additions or deletions have not been made. 5, a showing of the manner and preservation of the recording. 6, identification of the speakers. And 7, a showing that the testimony is voluntarily made without any kind of inducement. So if one has regard, your worship, with respect to the date of that matter, which was 1986, your worship, and things have changed since then, and those requirements were set out then, so one has regard to, as my learned colleague has stated, the capability for manipulation that we now have in all the safeguards, both in the statutes and in the practice of the courts, your worship. And it is my respectful submission that before my learned friend for the state can begin to produce evidence that is clearly intended to be prejudicial to the accused, there is an obligation to establish the authenticity, originality, and reliability. And by reliability, your worship, I refer in essence to the possibility of manipulation being excluded. Put differently, your worship, the significance of the chain of custody. So one cannot come to court and say, oh, here's a video, I'm showing it, without being able to show the court, under the heading of relevance, your worship, that this is relevant because it was filmed by a reliable human being that can attest to it and can attest to the fact that it was not manipulated. Absent a video recorder or cameraman, one can never attest to the reliability of the product because one doesn't know where it came from in its original form. And that's the problem that the state has in this case. There is no particular person that comes forward and says, I recorded this footage. So it can never be relied upon because of that fundamental flaw. And that's the distinction to State versus Fury, because Fury was, this is a photograph of what was depicted having utilized a camera, the reliability of which was not an issue, and there's no dispute that it had been properly set up and operated. So you have to, with respect to us, pass those two hurdles before one goes to relevance. And that's why I draw the distinction. And I do not, with respect, believe that the state will be able to get past those two hurdles before we get to the issue of reliability. If we had, by way of example, which will be as practical as possible, a video footage that wasn't 100% clear and somebody wanted to zoom in on a particular shot in that video, and the video was not an issue, then one could rely on a photograph of what came out of that video footage, provided the reliability had been proven. In other words, if my little friend showed you a video of us in court today, somebody came and said, I made this video, and he said, oh, we're not disputing it. And then someone says, oh, but if you look really, really closely, you see the fan was switched on because, and then they'd give a photo of the fan and you'd see some movement, or they'd do different things. But that's not the case yet. Here, we're going back to the very, very fundamentals and the basic issues here in dispute. There is no person, with respect to your worship, who says, I filmed this video footage. Absent that, we say one cannot then say, well, is it relevant? Because we don't know where it comes from. The state wants to rely on it. The defense isn't admitting it. Can your worship actually then view it? And I say unequivocally, the answer has to be in the negative with respect to worship. Thank you.
Thank you. Advocate Caesar, let me hear your application.
Thank you, Worship. I'm in agreement with counsel for accused number 1 insofar as the video evidence being real evidence is concerned. If it's real evidence with the normal rules of evidence is not applicable. I see counsel for accused number 1 have relied on an old case of 1986, a case which I must admit, Your Worship, has been heavily criticized. Bishop, if I can just open with a quote that in recent years technology has revolutionized the way we communicate, the way business is transacted, and ultimately the way lawyers practice law. The advancement of technology has created an entirely new source of evidence, being this electronic evidence in the form of video. In addition, electronic evidence plays a key role in criminal law, either as an instrumentality of the crime or the primary source of evidence relating to more traditional charges. In this particular matter, the only issue, we have a witness that was present on the scene when the video was recorded. In fact, we have two. I want to refer the court to a number of case laws that confirms that a trial within a trial is not the way to go regarding this, because the court has a limited discretion other than to look at the video and to see whether it's relevant to the charge which the accused are facing. In this regard, Your Worship, I'm going to support it in my argument that trial within a trial is not the way to go if one look at the case of State versus Baleka. It's 1986, volume 4, 192. It's a Transvaal decision. At page 194 to 195b. I have made a copy of this decision, judgment to the court, which I wish to hand in.
Thank you. If the defense requires a copy, we can also facilitate that and ask someone to assist. Would you want one, Advocate Oudez, Advocate
There
Matthews?
is one available.
Bishop, why things are put upside down already
Yeah.
now.
Take your time, not a problem.
Bishop, I want to refer the court to that particular quote in the judgment of State versus Baleka and others. In this particular case of Mr. Baleka, the court held, I've heard the argument by both my colleagues that the court held here that I would not hesitate to transplant this. There's an American case before that. To transplant the American species of the law of evidence in South African soil. In my judgment on the admissibility of video recordings, I refer to the particular requirements of their jury system. That was the ones that was already mentioned by counsel for accused number 1. I don't wish to repeat it. In my view, apart from identification, which may be a way of providing relevance, the rest of the above rules should not be prerequisites to admissibility. It follows from what I have said above, dealing with case tape recordings as I would deal with any other type of real evidence. Tended where admissibility is disputed. The test is whether it's relevant. It will be relevant if it has probative value. It will only have probative value if it is linked to the issues to be decided. That link will often have to be supplied by evidence of identification of voices on a tape where the identity of the speaker is an issue. This proof of relevancy need only be prima facie proof. As already said to your worship, we have two witnesses that's going to come and testify, that's going to identify the scene and the contents thereof.
When you say the contents thereof, what are you referring to?
The contents of the video and what is being depicted there. Consequently, no trial within a trial should be held on the question of admissibility, as the defense will, apart from contesting this evidence by cross-examination, not be entitled to lead any evidence on this issue at this stage. The defense can canvass the matter fully when it presents its case. It makes perfectly sense. If I can go further, that in the instant case I expressed some reservations on the calling of Mr. Ackerman. Mr. Ackerman was a defense witness that was called within a trial, So the judge acknowledged that he erred in allowing Mr. Ackerman, but it did not change anything, whether he was called or not called. By defense, but of turn at this stage, I allow this procedure as it was also followed in State versus Rangoban Supra to enable the defense to present its case on admissibility fully. Then the judge deal with a remark that he will not ignore the evidence of Mr. Ackerman. He will take it into consideration, but it wasn't necessary for him to come and testify during the trial within a trial. So the judge said that a trial within a trial have no effect, because at the end of the day the court have very little discretion to determine whether it is relevant. The above approach does not mean that sight is lost of the dangers inherent in tape recordings. The judge acknowledged that. All these dangers have to be fully weighed when the question considered at the end of the case, whether the state that proves its case on the tape recorders are reliable. The decision will be reached on all the evidence that's available, which include that of the accused, should they give evidence. It's only then will the court know which portions of the tape recordings are disputed. Whereas at present, the defense is merely indulging in shadow boxing. I can go on and on about a number of cases. There's also a case of Harvey versus Nolan and others. It's 2016 in brackets 2 SA 436. It's an Eastern Cape decision. It's exactly the same principle. Judge Pluskett was the judge here. It was a judgment that was delivered right here in the Eastern Cape and has been reported. I have a copy of the judgment which I wish to hand in to the court for the ease of reference. Exactly the same principle, whether it was relevant. I see my learned colleagues also touch on the section 15 of the Electronic and Communications Act, Transactions Act. This also provides the court with another option of just looking at the evidence. Because the video is real, it says it can be handed in terms of this particular section. There's also another section which the court can hand it in to consider section 3(1) of the Criminal Law Amendment Act under the hearsay evidence, because there is a witness that can identify the contents thereof. And the court, my submission that it is in public interest I can give the court a number of cases, except for the one that was quoted that was so heavily criticized for the lack of logic in that particular decision. used already in the Eastern Cape State versus Umpulo. Also in 1986, there was these two decisions that was taken. One is the Transvaal decision, Ram Goban, that was quoted by my learned friend. Then there was the one of State versus Umpulo, the one that it's a case that emanated from KwaNobuhle in Utenhage, where the Judge Mullins already decided at that stage that this is real evidence. In that particular case, the witness that made the recording was overseas. He didn't even testify. He sent it over to South Africa. They didn't even know who he was. The decision already was taken then. It's an issue of relevance. And that authenticity does not play a role when it comes to real evidence. I refer the court to Mahmoud versus Janssen van Rensburg. It's 1993, volume 1. SACR, page 67. It's an appellate division. And it goes at page 78. H2I, the state proved common purpose by the aid of video footage from the video surveillance camera. In all these decisions, State versus Fury has already been cited by my learned colleague. In People versus Dodgett, D-O-G-G-E-T-T. State versus Narayan, N-A-R-Y-A-N. It's 1998, volume 2, SACR 345. It's a Western Cape decision where the prosecution proved that the accused had the necessary intent by the aid of footage from a police surveillance camera in circumstances where an under-threat police operation was conducted. If I can refer the court in State versus Dube. Same decision. It's a 2000 in brackets 2 SACR 583. It's a Natal decision. State versus Udugo. O-D-U-G-O. 2001 in brackets 1 SACR 560. It's also a Western Cape decision. In State versus Smith, also same decision. State versus Pelay. Smith is 2002 in brackets 1 SACR 188. Transvaal decision. State versus Pelay. State versus Nel, MEC for Health in Mpumalanga versus Mnet. This was a video that was used to show in a civil suit by an undercover video footage to show how nurses in a hospital in Mpumalanga mistreated the patients who received abortions. Holthausen, 1984, volume 2, brackets 2, SA 852. It's appellate decision. The court held that the typed transcript of a tape recording is admissible as evidence of an intention to commit a crime. In all these cases, State in Nibot 1990 in brackets 4 SA 217. It's also a decision by the appellate division. where the court admitted the tape recording planted on an intrepid in a covert operation to obtain evidence in an illicit diamond buying deal. And last one, Your Worship, it's State versus Mdlongwa. It's a 2010 in brackets 2 SACR 419 SCA, where the court admitted video footage from a surveillance cameras installed at the bank where the robbery took place. All these decisions already in 1986, from 1986 up to onwards, have already confirmed that documentary video evidence is indeed real evidence, and that the normal rules does not apply. The only thing that the court have to look at is whether it's relevant, and that's it. And that the trial within a trial, it's really not the way to go. It's not a matter of authenticity. That's my submission. Thank you.
Based on that, I suppose there's a reply at
Your Worship, firstly, my learned friend craftily utilizes the words that the two witnesses were present on the scene. So that doesn't resolve any of the issues, and I will explain to Your Worship exactly why. Your Worship, the debate between these two authorities is fully dealt with in the authoritative book by Hoffman and Zeffert at pages 705 to 709. Each and every one of the cases, most of the cases referred to by my learned friend or referred to there in the Mullins decision. And there's a comparative analysis there, Your Worship, between these two decisions. So my learned friend firstly argues to Your Worship that you cannot rely on such an old case as 1986-4, and then in the same breath relies on the very same thing. The of 1986-4. It's just one of those anomalies in our law, Your Worship. They both are from 1986, volume 4. So, Your Worship, the learned authors, underlating photographs, films, videos, films, and sound recordings, which begins at page 704, deal with this very, very issue, Your Worship, from page 705 to 709. Your Worship, here we're dealing with authoritative authors who've studied this debate and devoted far more time to it than any of us, or Your Worship, with respect. There they say, Your Worship, that there is this distinction and different approach to the law between the Baleka decision and the Ramgobin decision. And they refer back to the Ramgobin decision at page 705, where it says it is not objectionable to ask a witness whether he recognizes a scene or a person in a photograph, even if he did not take the photograph, nor was present when it was taken, or even if the origin of the photograph is unknown. But if the witness said he did not recognize any person or scene in the photograph, it would not be admissible in the absence of proof that it was what it purported to be. The case of R versus W establishes that photographs and films must be identified as true representations of the objects and persons which they purport to represent before they can be said to be real evidence. Objects do not prove themselves any more than documents do. And that's using the example, the illustration that I referred to, Your Worship, to. The learned authors continue. The learned Judge President's statements have been italicized in this book to stress something that is of crucial importance. As we have seen, a document has to be proved to be authentic before it is received in evidence. So must a photograph, according to R versus W. By apparative reasoning, must a sound recording or a videotape, with or without an oral component, be proved to be a true representation before it can be admitted? Or does lack of authenticity merely affect the weight that has to be attached to such evidence? Divergent answers were given to this question in a number of cases decided by courts in 1986, and the Supreme Court of Appeal is yet to give a definitive answer, as our learned friend for accused number 2 stated. says, the approach of Norm JP in State versus Rand Goldman and others gives with respect the best protection against the abuse of films, videos, tapes and sound recordings. So here are the authors who studied this aspect of the law and have conducted a comparative analysis of these two cases, saying that the Rand Goldman approach is the best protection against the abuse of films, video tapes and sound recordings. And I want to go further, Your Worship, and say this is the clearest example, because while I can tell Your Worship, I have the photographer, I have the person who made that video. We put him we've challenged him. Instead, he tells Your Worship very craftily, they were present on the scene. He doesn't say, Your Worship, they never witnessed the incident in question, because that's the case. So I can be present in the court building, not knowing what's going on in this court. Does that qualify me, Your Worship, to come and give evidence of what occurred in this actual room? With respect merely to ask, has abuse in fact happened in the case that is being tried? This is precisely because in many cases simply does not know. That in a nutshell is the rationale for the approach laid down in State v. Rand Goldman and others in deciding whether certain audio and visual tape recordings were admissible. Previous South African cases offered little assistance. In State v. VEII, the appellate division had merely held that where the accuracy of a tape recording has not been established, it is not safe to rely on it without corroboration. The majority of the court in R v. Berman held that a dictaphone recording was inadmissible possibly because it did not adequately correspond with certain copies and transcripts. In S v. Peake, it was made clear that there must be proof that the evidence has to be what it purports to be, that there must be evidence aliunda establishing its accuracy. These decisions, he submitted, do not stand in the way of Norm JP's conclusion that the other dangers inherent in evidence of this kind have to be met. The learned judge present followed what had been laid down in State v. Singh and another, which was binding on him, which was indistinguishable in principle. It laid down as regards tape recordings that A, it has to be established that the recordings were original recordings and that if sufficient doubt is raised by the defense that they are not reasonable, the court must reject them. And B, if on the evidence as a whole there exists a reasonable possibility of interference, the recording is inadmissible. Norm JP concluded, however, that the rule laid down in State v. Singh and other was not an exhaustive set of requirements for admissibility for recordings to be admissible, but it proved, according to Rand Goldman's case, that they, A, are the original recordings, and B, that on the evidence as a whole there exists no reasonable possibility of some interference. In a criminal case, the state must also prove that the tape recordings do relate to the occasion to which it is alleged they relate, that they are faithful, and prove the identity of the speakers. There must be a witness to the event purportedly recorded on the tape to testify that it accurately portrays that event. Now, my other friend says they were present at the scene. It doesn't say they witnessed the scene. And that's the distinction, that's the dangerous distinction that is incapable of curing on the facts as known to us from the docket, Your Worship. They then drew a distinction between the tape recordings and video recordings and sound recordings. There's reference to the Mullen's decision. But at the end of the day, Your Worship, and I will show that the learned authors clearly advocate for the approach in the Rand Goldman decision, which is quite clear from the following. At page 707, they say, this view in our submission is misconceived. A, the fact that it is real evidence does not mean that it proves itself. And B, Norm JP has shown lucidly and with great force in Rand Goldman's case that there should be prerequisites to admissibility precisely because having them is the best way of guarding against the grave dangers inherent in this kind of evidence. They then go into the cases again, and they say at the bottom of page 707, it is submitted that in both instances they should not be treated differently, both the originality and authenticity should be proved as requisites of admissibility. They then quote the cases that Van Dijkers had reference to, the older cases, and they then go through what should happen. And at page 709, and this is where the conclusion comes, Your Worship, after going through, and I've read, Your Worship, the 7 requirements from Rand Goldman's decision, the last paragraph before this reference to the Fourie decision, Your Worship, reads as follows. If the learned judge present is correct in his view that authenticity goes to the admissibility of evidence of this kind, and in brackets they say it is respectfully submitted that he is correct, factors 1 to 6 constitute useful if not exhaustive criteria for admissibility. Factor 7 of course, is subsumed by a law relating to admissions and confessions in criminal proceedings. If not, they are valuable criteria for the assessment of weight. And then there's reference to the authority that Your Worship referred to, State versus Fury. And as I've said, and I'm going to repeat myself, unfortunately, Your Worship, they say, in State versus Fury, it was held that a photograph of a moving motor vehicle by a so-called speed camera was admissible without the witness testifying that it was a correct image because the reliability of the camera is not an issue. There's no dispute that it had been properly set up and operated. And that's the distinguishing factor, Your Worship, that here it's not the case. In fact, Your Worship, just to page 707, they refer to one of the co-authors erroneously arguing that the decision in Baleka was correct. And this is at 707. It says that it argued erroneously by a co-author of this book that this approach has a commendable lack of authenticity. It makes more sense to receive a copy and evaluate its weight in the light of all the evidence. The rhetorical question has been asked, why should the court be precluded from considering its weight because of a rigid exclusionary rule? This being our submission is misconceived. A, the fact that it is real evidence does not mean that it proves itself. And B, Monjak has shown lucidly with great force in Gordon's case that there should be prerequisites to admissibility precisely because having them is the best way of guarding against the great danger inherent in this kind of evidence. So let's try apply it to the facts here, Your Worship, and not be too academic or too rigid in our approach. If, for instance, Your Worship, somebody claims to have a video of this particular scene and says, here's a video, and plays it to the court, without being able to say, this is the person who made this video and can attest to its reliability, in essence, Your Worship, it would be misleading this court, is the argument that we have. Absent a person who says, I am the cameraman, this is how I set up the camera, this is what I personally filmed, and that's the important part. I can film up, I can set it up, I can leave. But if I never filmed it, it doesn't say anything about the reliability of that which is captured in the video footage. My learned friend needs, the state needs, in this instance, somebody says, I sat there and I filmed this and this is what I saw and filmed at the same time. It's a contemporaneous recordal of what I saw. Absent that, it's unreliable, and he cannot, with respect, satisfy that requirement here. And he knows it, and that's the problem that he has here. Therefore, we object to it.
Anything you wish to add, Advocate Matthews? Advocate Caesar, do you want to reply to Advocate Odes?
Just on 2 points. Your Worship, I didn't say the 1986 case of Ramgoban is irrelevant. I didn't say that. I said it was heavily criticized. Just want to rectify that submission made by counsel for case number 1. Secondly, Your Worship, there is the case that I've quoted, Madlongwa 2010 is number 2, volume 2, SACR 419, SCA. It's a Supreme Court of Appeal decision. There is a decision in this regard.
It is?
There is a decision regarding that. I think my colleague said there's no, so for the Supreme Court of Appeal have not really pronounced it. There is a case. Thank you. That's
Thank you. I've recorded, and you may correct me here if I missed anything, because it's been at a quite fast pace. I think it was during your address, Advocate Odes, that you suggested a trial within a trial would be the appropriate way to decide regarding admissibility. You still request that? Is that also the view of yourself? Just for clarity as well, and it's also just so that if I have to go back to the drawing board, I've got the inputs and the state's inputs. Mostly then your two requirements for the trial within the trial is whether the evidence will be detrimental to the administration of justice, if it will render the trial unfair, and further if there was an infringement of any right as contained in the Constitution. So what is your application specifically based on?
That would go back to the Nigel decision, Worship, in the TEL. And yes, Worship, to allow evidence of this nature would be detrimental to the trial, would bring the administration of justice into disrepute and be prejudicial to the accused, because my learned friend cannot prove the reliability of the evidence. So one cannot say it's relevant but unreliable. One must first prove it's reliable, and then one can attend to the issue of relevance.
Thank you. So no infringement is being brought into this.
Well, the court has a duty to ensure there's no infringement. If the court were to sit back and allow all types of evidence to be admitted without ensuring that the evidence is reliable, it would result in unfair trial to the accused, clearly prejudicing the accused.
Thank you. Anything you wish to add, Advocate Matthews?
From our point of view, we're looking at this as a matter of authenticity. Is it very authenticity, and can it be the originality of it be proved by the state? Why I requested a trial within a trial, my lady, is because Hoffman and Zephyr, in dealing with the proof of such evidence, suggest that it be done within a trial within a trial. So that, sorry, if I could just get to that issue. Well, they suggest that the matter be decided in a trial within a trial. It's much safer to do it that way, so that inadmissible evidence is not led in the main trial. And then, of course, when they come to the decision that it's not only authentic, it's the original and it's admissible. if that is the result of the trial within the trial. It's just a safeguard to me that if we do it that way, it's much safer than doing it in the main trial.
Thank you. Nothing else?
My submission remained the contrary, Marriage.
In an ideal world, it would have been wonderful had I been informed prior, so you have given me a lot to look at and to read. I'd like to be optimistic and say after the lunch adjournment, but I cannot be 100% sure. There's a lot quoted by the state defense for accused 1 as well as accused 2. To the learned authors, I need to satisfy myself that I am in agreement. So there's a lot. My second problem, delay that I foresee if we don't utilize as much court hours is, let me just confirm, Sergeant Pienaar, is our go-to guy for load shedding schedules. Can you give us, is there any load shedding tomorrow, or are we spared? 9 to 12. So that's ESCOM. 9 to 12 load shedding. So that means courts do not function. It comes to a standstill. Recording machines can't be switched on. Thereafter, it takes 30 minutes for the server to kick in. It eats up our court time. we work through tea, before court, lunchtime to catch up. So at this stage, I think I will leave you to the decision if you want to risk and take the chance and wait for me possibly if I'm ready, or we resume then at this stage until tomorrow 12:15. Do you want a few minutes to discuss and then just call me?
Worship, speaking for myself, I don't want to put your worship under any more pressure. The issue of the trial within the trial is on pages 506 to 513.
Are you still on Zephyr?
That's just on the issue of the trial within the trial.
5?
Worship, it's unfortunate, worship, we cannot express it. It's up to worship, and worship will be ready. If it's this afternoon or tomorrow, we entirely in worship sentence. We respect, and I know you have other pressing issues to deal with as well, and I know that ESCOM has to be taken into account and the lack of power, so we in your worship sentence.
Okay. For us to utilize, I don't have a list of any witnesses or possible witnesses. May I inquire, is there any other witnesses available which we can proceed with today, which is not pertaining to the video or the footage or the clip?
No, Your Worship. Everything is about, all the witnesses are regarding this.
Okay. I thought we could.
When your hands I have, I think it would be safer if we just continue tomorrow.
Yes, I
Already I've
think
been
so.
referring to an article, Admissibility of Electronic Evidence in Criminal Proceedings. May I hand this up to you? It's just
Any aid is welcome.
it's just an
Thank
aid.
you.
Sorry if I may ask my ballistic expert some work for the day.
Thank you very much. Thank you. All right.
Your Worship, there's also a document my learned for the state was the handing that you didn't have copies
You
of.
didn't hand
I
it
did.
in, yes.
As Worship.
Do you still wish to do so, Advocate Caesar?
No, it's already been handed in, Your Worship. Thank you.
Did you hand it in? I thought that was the second one. So you were initially looking for the Harvey matter that you wanted to settle.
You can keep mine, but I have written on it. So I'll make another copy.
Your Worship, I don't have Worship as I have Hoffman and Zephyr.
Sorry?
I have only the text of Hoffman and Zephyr. Most apologize.
I found
Much appreciated. We also do not have books here. Thank you. Thank you. Now I think I can validate that tomorrow would be the best option. All right. At this stage then, accused 1 and 2, if you may stand up please. I think the reasons that we've mentioned is quite clear. The application by the state and the objection by Advocate Odes and Matthews must be considered. There's a lot that the court needs to do this afternoon pertaining to the application. Due to load shedding tomorrow, unfortunately, court will start more or less 12:15, pushing 12:30, depending how long the server takes to kick in. Therefore, I'm not warning accused 1 and 2 for 8:30. That's pointless. So all parties, you can decide with your clients, but that we at least start to be present by 15:15 in case we can start. For the ruling by court, and then we will take it from there.
That's good.
Thank you.